A man shoots his girlfriend in front of her 15-year-old son, then turns the gun on himself. Both survive, but the victim is left permanently disabled. Shockingly, prosecutors try to offer him a sweetheart plea deal, completely dropping the attempted murder charge. Will a no-nonsense judge actually let him get away with it? The tension in this murder hearing is suffocating. A heartbroken family steps up to look a cold-blooded killer dead in the eye. With raw grief, they deliver gut-wrenching statements, calling him a coward and a monster. After facing the family's wrath, what kind of sentence will this killer finally get? A 22-year-old perfect guy with a steady job and a spotless reputation is caught in a police sting targeting a 15-year-old decoy. Armed with his mother's tears and a defense lawyer blaming his actions on grief and drugs, he begs the judge for probation instead of prison. Will the judge buy his excuses or send him behind bars? Welcome back to Justice Judged. Let's enter the courtroom.
The state appears through District Attorney Kevin Schmidt in person. We have Mr. Winquist appearing in person in custody with counsel Eugene Harrington. We're set today in this matter for an oral ruling. The parties have requested that the court review and approve a plea bargain, a plea deal that has been presented. We are in victims' rights compliance?
Yes.
All right, we are in victims' rights compliance at this time. Although I'm going to be making an oral ruling right now, I'm only going to give you a gist or a brief summary of what my decision is. I have a full written decision that I will sign immediately after this hearing, and the parties will have access to. The reason why I am not going to submit it right now, or I'm not going to read the decision because it is 13 pages. So it gives much for the parties to review and to discuss, but I'm going to say this was a very difficult decision to make. I have in front of me allegations of very heinous crimes that cause significant and permanent physical and emotional harm to a person and left a juvenile emotionally scarred. I have two attorneys whom I respect thoroughly, who understand the law and know the facts of this case thoroughly, more thoroughly than I have been provided. I only have access to the facts in the criminal complaint, the statements made during the hearings by counsel, and the facts that as they are outlined in the defense's stipulated facts memorandum. A plea bargain requires a court to have thorough review of what it has in front of it. If a prosecuting attorney has agreed to seek a charge or sentence concessions, they must have the approval of the court, and the court must personally inform the defendant that the prosecutor's recommendations, that the recommendation, this joint plea bargain, is not binding on the court. This bargain, this plea deal, must also be evaluated to ensure that it serves the public interest. The court's duty and role is to safeguard the public interest, to substantially ensure the benefits and the advantages to the public. Deciding whether to reject a plea agreement is firmly within this court's authority and discretion. It is vested in me, the judge, and the circuit court to determine what pleas do serve the public interest without allowing the court to interfere with the prosecutor's authority when the prosecutor decides what charges to file and whether to file charges at all initially. There are certain factors that a prosecutor considers when deciding whether to file charges, and these factors somewhat overlap with the court in determining public interest in whether to accept a plea. These include such things as extent of harm caused by the offense, threat posed by the public or to the public by the suspect, the ability and willingness of the victim to participate, the disproportion between the authorized punishment of the particular offense or the offender, possible improper motives of the complainant, cooperation of the suspect defendant with the arrest and prosecution, the possibility of a likelihood of prosecution by another jurisdiction. That doesn't affect our case. Accordingly, these factors that a court must weigh when defining a public interest and what interest is involved, it varies from case to case. I must look at each of the facts and look at each of the cases separately. One appropriate factor for one case may not be something considered in another case. Things that the court looks at and reviews would be such things as viewpoints from law enforcement officers, as well as other things, which it's not an exhaustive list, but I must take into account the public's right to have crimes that are actually committed to be fairly prosecuted and to protect the rights of third persons. The court must evaluate the defense attorney's reasoning and arguments and recommendations and balance that with the public interest and with the prosecutor's arguments to seek a fair prosecution. Other components of a public interest that the court must consider include whether the defendant has voluntarily and intelligently entered into a plea bargain, whether a factual basis exists for a guilty plea, the general public's perception that crimes should be prosecuted, the interests of the victims, the court's ability to dispose of a case in a manner to commiserate with the seriousness of the criminal charges, and the character and the background of the defendant, and the plea's usefulness in securing a legitimate and important prosecutorial interest. It has been observed that there may be situations where the public interest might be better served by having a case tried rather than having it disposed of with a guilty plea. The court has reviewed the facts of this case, the information, the complaint, the transcript for the preliminary hearing, the defendant's admission of facts, and the defendant's memorandum regarding the public interest of the plea. I've also heard very thorough, thought out arguments by both attorneys and an impactful statement by the victim. The court wrestles with the notion of accepting a plea in totem. That means to accept the plea as it is fully presented to the court as a complete agreement. Standing alone, the amendment to count one may likely be appropriate and would meet the public interest consideration. The rest of the plea agreement causes skepticism and trepidation. The court has a responsibility under case law in its higher courts to reject a plea agreement that does not serve the public interest as a whole and not simply in parts. The plea agreement as extended and when compared to the allegations of the criminal conduct with the facts available to the court gives the court apprehension. What jumps out in the record is the nature of the facts within the criminal complaint and the preliminary hearing transcript regarding the specific allegations of the defendant's criminal thinking. His blatant, utter disregard for public safety, in addition to his complete and total disrespect for the law. There are situations, again, where the public interest is better served to have a case tried rather than accepting a guilty plea and disposing of a case if the plea agreement as a whole is not appropriate and does not meet the public interest. The essence of this case remains: the defendant was not legally allowed to consume alcohol due to being on active probation with an absolute sobriety condition. He frequently binges on alcoholic beverages and is often intoxicated. He cannot legally own or possess any firearm because he is a convicted felon. He either has been diagnosed with or shows symptoms of PTSD from his military service and other life traumas, and did not seek therapeutic or other medical services to address it. He is aware of, or should be aware of, his history of experiencing a sleepy, dreamlike state, which is unpredictable and has violent outbursts upon sudden awakening. And worst of all, he unlawfully keeps a loaded firearm next to his bed, and throughout the house has multiple other firearms stashed away. And he is fully aware of all of the above. The defendant's knowledge of the above, combined with the defendant's intentional conduct and behavior of disregarding the law and violating probation conditions, not only puts the community at risk, but also creates a safety hazard with the potential for a significant probability of death or injury to himself or others. Taking all into account, combined with the victim's allegation of the shooting, the court is concerned that accepting the plea deal as it has been extended would convey an undesirable message to the public, suggesting that the conduct is not as horrific and gruesome as it may have been. The plea would lack the deterrent effect needed to prevent others from engaging in similar serious criminal conduct and behavior. The court need not accept the plea offer as presented unless the court is convinced that the state and the defense with certain facts exist. If the district attorney is publicly stating that the state cannot prove in a court of law beyond reasonable doubt that an impartial and unbiased jury of the defendant's peers would find the defendant engaged in allegations related with each, and I am specifically stating each charged account or any associated subsequent or lesser offense, that would be one thing. However, with this case, the attorneys are simply informing the court that considering the facts and the evidence, count 1, first-degree intentional homicide as an attempt, is not the accurate charge, as the evidence points to a lesser included charge, and a more appropriate charge would be, as the parties have agreed, second-degree reckless endangering the safety with use of a dangerous weapon modifier. And that may be accurate and true. The court notes that as the facts are outlined in the case, the modifier is, for the most part, meaningless and does not increase penalties, sanctions, or otherwise. Additionally, as part of the plea bargain, the defendant would plead guilty to only one count of felon in possession of a firearm. The remaining 6 Class G felonies for a felon possessing a firearm would be dismissed and read in, along with the other misdemeanor count for operating a firearm while intoxicated. Again, the attorneys are not telling the court that the other 7 criminal charges cannot be proven beyond a reasonable doubt, only that count 1 is not accurate and it is not the correct criminal charge based upon the facts and the evidence of the case. The maximum possible penalty the defendant would face with the plea deal would be 12.5 years of incarceration and 5 years of extended supervision. Even if the matter proceeds to a trial, as it is charged, and if the defendant is found not guilty on count 1 as charged with no lesser included, if found guilty on the remaining counts and charges, the defendant would face a maximum possible penalty of 35 years and 9 months of initial incarceration with 35 years of extended supervision. This is a significant reduction in the incarceration length hanging over the defendant's head. The court is looking at all of the information and the arguments and hearing the impact of the victim and the impact of the juvenile victim. And in viewing the gravity of the offense, if the facts presented to the court are accurate and factual, this case is so serious and so severe that it would depreciate the seriousness of the offense and promote disrespect for the law if the court accepted the plea deal. Further, it would not promote a public interest or be a deterrent factor to others. Even though the defendant is making concessions to plead to a serious charge and is accepting responsibility for some of his conduct and actions, the plea would not have the deterrence effect to prevent others from engaging in similar criminal thinking and a total disrespect of the law and the entire criminal justice system. The defendant was not only on probation at the time of these actions, but was also being monitored by the law enforcement and by probation with certain conditions and mandates. The defendant knew what conditions he must follow and abide by. He knew he was a convicted felon who was legally forbidden from possessing any firearm for life for any reason, no matter the reason or the excuse. Bears, squirrels, protection from burglars, or zombies makes no difference. The defendant is a convicted felon and has no legal right to possess a firearm for life. He intentionally disregarded that prohibition and spat at the legal system, believing he was above the law and could do what he wanted as he wanted. What happened that day was one of the most serious crimes that could have happened in a situation like this. The only worse outcome would be if the victim had died. Even though the defendant accepts the offered plea deal and admits to guilt, or would admit to guilt, thus eliminating the need for a trial, that is not a decisive factor. The impact on the victim must be viewed as well. The victim in this case is not opposed to a trial. Even if the defendant can prepay $10,000 or more in cash towards restitution, or could pay all of the restitution off at once to the victim, it is not a conclusive factor for the court or the victim. All components of this deal show that the defendant is not accepting the plea deal and admitting to guilt to limit the victim from public scrutiny, embarrassment, or trauma. Rather, the defendant is accepting this plea deal and would be admitting to guilt for his benefit and gain, the reduction of incarceration exposure. The victim and her son expressed that they would rather go to trial and have a jury of their peers determine whether the defendant is guilty on all charges rather than the court accepting the plea deal. The victims, in theory, could be re-victimized if the court accepts the plea as proposed. The state and the defense argue that there is inadequate evidence to prove and support count one as charged. The court is not making that determination. The jury is an impartial and unbiased decision-making body. The jury will determine the credibility and the believability of the facts, testimony, and evidence presented at trial. The state could request of the court permission to amend and file an amended information. If the matter does proceed to trial, should the jury find the defendant not guilty on count one, attempted first-degree intentional homicide as charged, without a lesser included offense presented, the victim must abide by and accept the decision of the jury. Even count one, not part of the equation, there remains 7 additional counts in the information. There is a possibility that the jury could find the defendant guilty beyond a reasonable doubt with the remaining 7 counts, thus increasing the potential sentence exposure to the defendant, leaving the court with a sentence determination. So as I have tried to outline and identify, the court is not accepting the plea deal as proposed. The court would consider any additional plea deals if they are constructed and gathered, but at least at this time, it's not received. Mr. Schmidt.
I understand. Thank you.
Mr. Harrington.
Judge, I would request that the court reporter prepare a transcript to expedite the transcript. The court, also, because this is dean appointment, request that the court authorize me to inquire of appellate counsel for the purposes of interlocutory appeal.
Must do that in writing, and the transcript's going to say pretty much a lot of what is in my written decision, but you'll get both.
I need both. I need it expedited because the time for the request for interlocutory appeal is 10 days, if I recall correctly.
20.
10, 20, it doesn't matter. It's a holiday week next week. And then one final question, as it relates to interlocutory appeal and the evaluation of that as an option to the defendant. Will the court permit second-degree reckless endangering safety with a firearm to be a lesser included offense to the count 1 as alleged in the information? It goes to a jury. Do we get to use that as a lesser included offense? It's kind of a premature question, but
It could be a premature question, but I may not have been as specific in my statement to the attorneys. The attorneys know the facts better than this court. Attorneys know the facts more in and out than this court. And whether or not, as it relates to intentional homicide, even as an attempt, whether or not the facts would be applicable or they would be able to meet each of the elements of that crime. As I stated, the attorneys have reviewed this. The attorneys have determined that second-degree reckless with the modifier may be a more appropriate charge. The state can always amend the information or can be a part of a different plea agreement, plea deal with other things included. Count 1 was not the issue for the court.
that raises another issue that I may have to consider for an appeal, but I understand. Thank you, Judge.
We're totally fine going through with the trial with all 7 counts or all 8, 9 counts as they've been charged. And the court is simply saying the jury, the unbiased decision-making authority who determines credibility and believability of the facts, as well as the testimony of the witnesses, gets to determine whether or not count 1 through 9, they find beyond a reasonable doubt guilt. As far as this court's concerned, we have a jury trial for count 1 through 9.
What's our next status hearing, Judge?
Whenever we set it, we're going to set it right now. We have a final pretrial September 4th, jury trial in October. What are you looking for with regards to status? How far out? And again, the case law specifically says the court has discretion to reject a plea agreement as is, and I'm rejecting it, and we're going to trial.
I agree. That's what the law says, Judge.
What are you looking at? How far out?
Do you want to revisit this 17, 18 of July? You and I will revisit before then, but
Why don't we talk after this hearing? I think you might have heard things from Judge that she didn't say.
And you're going to get my written decision right here that says everything that I said.
sure.
Everything I said. All right. So I don't have the ability to do the 17th or the 18th, but
The next week of the 21st.
1:30 on July 17th. And if you're requesting a transcript, it must be in writing to the court reporter.
I'll send you an email.
All right. Anything further?
Not for me.
Mr. Harrington?
Thank you, Judge.
Thank you. We are adjourned.
For my daughter. Okay. Unfortunately, I'm not there to say this in person, but I know the sentence you were given to spend put away is nothing compared to the literal death sentence you gave my dad. You're a complete coward, and I hope you live the rest of your life in shame and guilt. I walk the stage to graduate in 3 weeks, and I won't have my dad in the stands watching me because of you. You're a monster, and I promise to make sure everyone, including those you love, will see it. You get the freedom of getting visits from your kids, while me and my siblings get the pain of visiting a cemetery. When you do get those visits from your kids, I hope all they see is a criminal, a monster, and a disgusting human. One day, these same words will come to you again, but from my mouth, and I'll look at you in your face as your life goes downhill the way you looked at my dad and took his life. I promise you won't live to see a normal life again as long as I'm around. I'll make sure your face is engraved in people's heads so when they see you, they will see a murderer. My dad taught me and my siblings to be strong physically and mentally, so I assure you that I will get justice for my dad one way or another. This isn't the end, so remember, please, with these words with every day that passes.
American Justice Files.
Court is calling 2022 CR 8635, State of Texas versus Bondale Skirvin. Could I have parties announced for the record for the state?
Brittany Mitchell for the state.
For the defense?
Jay Norton for Mr. Sterling.
Are you Mr. Skirvin?
Yes, ma'am.
Counsel, have you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Thank you. I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we are proceeding on count 1, paragraph A.
Any objection?
No, ma'am.
Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
You understand you're charged with the offense of murder. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years up to life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. You want to go around?
Thank you.
If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, in my opinion.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Mrs. Skirvin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1, paragraph A. Punishment is to be assessed at 35 years in the prison. There's an affirmative finding of a deadly weapon and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, ma'am.
State?
Yes.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then to count 1, paragraph A, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Your Honor, we have to state exhibit number 1 in all attachments.
Any objections?
No, Your Honor. Mr. Scrivener and I have gone over those documents together.
All right, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right. Is there any victim impact?
Yes, Your Honor.
All right.
We have, obviously, there's a lot of family and friends here. There are 3 that would really wish to address the defendant.
All right. So we're going to go off the record. Mr. Skirvin, in this courtroom, I require that everyone treats everyone with respect. So family members of the complainant has something they want to say to you. So just internalize it. They are going to be respectful. All right. Who wishes to speak? Okay. All right. If he wishes to, he can stay there. That will make it easier for the deputies.
I'm told brother, to me, you a coward. 35 years ain't no time. You know what I'm saying? I respect this courtroom, so I don't feel like you remorseful. I feel like, you know, what you doing is fucked up. See my language.
All right, so everyone, here's the thing. Here's the thing, everyone. I understand that tempers are high, and they're always high in these cases in felony court, but I understand that they're even higher when it involves a murder case. And I understand that someone has lost a loved one. I do understand, but we are not going to use profanity in this court. If we do, what will end up happening is there will not be a victim impact statement. So when people start using profanity in court, start swaying back and forth the way you're swaying back and forth, that puts deputies on high alert, and that makes the court not safe the way it should be. All right, so this is what I would like you to do for me. Have a seat and speak from a seated position. That will make it easier for everyone. And if you want to, you can sit on this side so that he'll be able to see you, because I know there's equipment in the way. And that just makes it easier for everyone. All right, you may proceed.
You know, you take my brother's life. He got kids. You ain't thinking about none of it. You know what I'm saying? Y'all would never know how it feels to lose a loved one because you're a coward. I'm from the streets. I know what it is. So, but I'll never respect this because you did it in a cowardly way. You know what I'm saying? You take my brother's life for what? For nothing. For nothing. Because you was a coward because you couldn't face that. My brother was a good man, good father. Worked real hard. Took care of his kids. I just came home from doing 11 years. And I didn't even get to see my brother. You know what I'm saying? So, if you feel like that 35 is justified, none of us feel that way. But that ain't for me to judge, it's God. So, with that said, I hope when you sit in there, you really realize the life that you're taking, it ain't gonna never just be what it is. You can't get that back. His kids can't see him. He can't see his kids graduate. What my mother go through every day. My dad, the rest of my family, those that can't be here and speak. Words can't even too much explain how we really feel. But you're gonna always be a coward in my eyes. Always. And I'm just gonna leave it at that. Because I'm gonna let my words be few.
All right, thank you. Who's the next person?
So I'm just gonna speak on behalf of the community. You took his father for my daughter. Okay. Unfortunately, I'm not there to say this in person, but I know the sentence you were given to spend put away is nothing compared to the literal death sentence you gave my dad. You're a complete coward, and I hope you live the rest of your life in shame and guilt. I walk the stage to graduate in 3 weeks, and I won't have my dad in the stands watching me because of you. You're a monster, and I promise to make sure everyone, including those you love, will see it. You get the freedom of getting visits from your kids, while me and my siblings get the pain of visiting a cemetery. When you do get those visits from your kids, I hope all they see is a criminal, a monster, and a disgusting human. One day, these same words will come to you again, but from my mouth, and I'll look at you in your face as your life goes downhill the way you looked at my dad and took his life. I promise you won't live to see a normal life again as long as I'm around. I'll make sure your face is engraved in people's heads so when they see you, they will see a murderer. My dad taught me and my siblings to be strong physically and mentally, so I assure you that I will get justice for my dad one way or another. This isn't the end, so remember, please, with these words with every day that passes.
Okay. Is there anyone else?
Final one.
Your Honor, I'd ask if I could use the microphone. You have nothing to worry about me.
Okay.
Christian
Oh,
man.
no, I understand.
Microphone or amplifier. You referenced the book twice, reading books twice. I'm reading a book right now, and it has everything to do with the impact of words. And if this is victim impact, I want to use clarity.
Oh, well, I can tell you that I'm the furthest person away from everybody, and I can hear you. All right. But thank you for that. I appreciate that.
I didn't write anything down. On Dale Skirvin. I'm trying to speak on behalf of Mark, Brenda, April, Crystal, Matthew, Elijah, Daniel, Sabrina, Brianna. These are most of the siblings. I'm sure I forgot some. Also on behalf of Dominique, Zanaya, and Joshua Jr. These are his kids. That's direct impact. I'm just a brother-in-law. I'm just a brother-in-law. When I have to hear his mother, Antonia, say that you get to still see your family. Coming up on Mother's Day. My fear was that we were going to ask for time for that. I thought that would have been very unsuitable. Because none of who I just mentioned will ever get to see him again. And you didn't take a thug or a gangster away. You took a good man. To be a Christian man. My wife said, April, she said, make sure he knows that on behalf of her and everybody that agrees with her, that they forgive you. Because it's just in the Bible, I know I do too. I have to. I implore you to read the book of Job. The book of Job is a complicated book. It's one of the hardest to read because it's a man that followed God with everything that's going to learn now, but it's so hard. Look at you because can't help but think on November 21st, when I'm talking to the doctor outside of 309, the room he died in. And I asked him how many gunshots did he receive? And the doctor says, we can't even tell. And you as a human being get to stand there and be honest as you could. Do you perceive what you did that in front of your kids? I gotta forgive you because I can only hope that your kids do the same for you. I thought I was gonna be cool when I came up here and I forgive you. I forgive you and I hope God does the same. But just know I named those names and that's just the beginning of it because you took the life of the party. You took a human being that was anything but nothing before being the best father that I know. And I'm a great father. And you did that in front of your own kids. I don't know what was going through your head when that happened. That's for you and God. I actually came up here on behalf of my wife. I didn't realize I could say so much, but wanted you to know on her behalf, forgiven. God forgives you.
Here in States Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, ma'am.
Anything you wish to say on behalf of your client?
Judge, Mr. Skirvin is just remorseful. He's never been in trouble before, and he understands it's a significant sentence, and he just asked the court to follow the plea agreement.
All right, the court will follow the agreement, sentence you to 35 years in prison. There's an affirmative finding of deadly weapon. The court will give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, court is calling 2025 CR 009749. State versus Cullen Spencer O'Neill. Can I have parties annexed?
Samantha Lynn Brown for the state.
Brian Kimbrough for Mr. O'Neill.
All right, and are you Mr. O'Neill?
Yes, ma'am.
All right, according to your plea bargain agreement, punishment is to be assessed at a cap of 8 years in the prison. The state is opposed to your applications. Have both parties had a chance to review the PSI report?
Yes, Judge.
Yes, Your Honor.
Any objections to the PSI report?
No, Judge.
No, Judge.
All right, state, you're opposed. Do you have any witnesses?
No witnesses, Judge.
Defense, any witnesses?
Yes, we have some witnesses, Your Honor.
All right, call your first witness.
Before I do, Your Honor, I have some letters that I wanted to present the court on his behalf, and I believe, and I did give a copy to the state, and I believe they were opposed to my doing so. So I wanted to give them an opportunity to speak to that.
All right, any objections to the court reviewing the letters?
Yes, Judge. I'm going to oppose their hearsay. I can't cross-examine the witnesses on those statements, and I don't believe they're sworn statements either, so I'm going to object to them.
Well, Your Honor, I've produced, these have nothing to do with the incident. They're only about the character and the information about the defendant. I think it's part of the court's duty.
So with regards to whether they're hearsay or not, the court needs to review it to see if it is hearsay. And then
You can rule.
if the court determines it is hearsay, then the court can always disregard. All right, with regards to the state's objections to the court reviewing the letters that have been tendered by the defense, the court understands your objections. The court is going to overrule those objections. The court will take these into consideration in sentencing.
Would you like to have a copy so they can review them?
Oh, I've reviewed it. Yes, I read very fast.
Very fast. Thank you.
All right, call your first witness. All right, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, state your name for the record.
Tammy Hollis O'Neill.
All right, counsel, you may proceed.
Thank you. And what is your relationship with Cullen?
Yes, I'm his mother.
And could you tell me a little bit, was Cullen raised in San Antonio?
He was raised in
Okay.
San Antonio, born in Japan, but came here shortly after that because his late father was in the military.
And how long was his father in the military?
24 years.
What branch was he in?
Air Force.
Are you also in the military?
No, sir, I'm not. I work as a civil servant, but not now because I'm furloughed.
Because government is
Yes,
shut-
that is correct.
shut down.
That is correct.
The Air Force?
I do work for the Department of Defense. That's correct. Air Force. Yes, at the Air Force Civil Engineer Center.
So Cullen's father passed away 7 years ago, right?
Yes, sir.
And
2018.
how did that, from your perspective, and was Cullen living with you at the time?
Yes, sir, he was.
And how did this affect him? The death of his father?
Hugely. It affected all of the kids, right? My daughter as well. But I think it struck Cullen much harder, right? Because of that father figure that he had in his life. And also that father figure to hold him accountable.
And how many siblings and other members of the family did he grow up with?
Yes, he has a younger sister who's not here to testify today, ma'am. One of the letters was from her. She's full-time in college and couldn't come. And then he has a stepsister as well.
And could you describe his upbringing, his childhood? Was it normal? Was it good?
Yes, sir. It was good. I would say it was good. He got everything he wanted. You know what I mean? One of those. And I did the best to raise him. With my husband, and then as a single mom after my husband passed away.
Did Cullen go to school?
He did. He graduated. He's got a diploma.
He's got a diploma. He didn't get a GED, right?
Yes, he did.
Yes.
He
But
did.
He did.
He struggled a lot in school with ADHD, and also so he has struggled with that throughout his life since he's been little, right? Hard to concentrate, anxiety, right?
And has he been employed, generally speaking, since he got out of high school?
Yes, sir. He has. He has.
Has he always sought employment?
Yes.
And to your knowledge, has Cullen ever been convicted of anything, any crimes in his
No,
life?
sir. No, sir. This is so outside of his character. And I have never witnessed this type of behavior in him,
Okay.
which is why this is so shocking. I've had so many conversations with him, and I think he regrets what happened, right? I feel like from his personality, this is just not something he typically would have done. And I feel like that it was a mistake. He just made a poor decision, a very poor decision.
And he's always lived at home, correct?
Yes, sir.
And so you've gotten to know his friends.
Yes, absolutely.
Okay. And would you say, based on your knowledge and your observation, are his friendships appropriate age-wise?
Yes, sir. I've never seen anyone under legal age at my house. That's another thing I think that my daughter wrote in her letter, that even when I'm not there, she didn't witness that either as well. His relationships have always been with people of age, which is why this incident was so outside of his normal character.
And has he had friendships that were long-standing? In other words, friends that he's had for many years?
Oh, yes. He has friends that he went to kindergarten with, right? And one is here today, actually, so.
Now, you know that we're here to ask the judge to place Cullen on community supervision.
Yes, sir.
For adjudication.
Yes.
You think that he could succeed on community supervision?
Yes, sir, I do. I very much do. I think that he needs that discipline, right? Of being able to check in continually. He's been on an ankle monitor for the last year and a half and has done that very successfully, right? To be able to check in and be accountable to that. I think that he can give back to society by working and doing other things while he was on probation versus if he was incarcerated.
Okay. And that's fine. Pass the witness.
All right, any questions?
No questions, Judge.
All right, thank you.
Thank you. I appreciate your consideration. Thank you.
And I would call Deborah Higgins.
All right, can you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Deborah Higgins.
All right, counsel, you may proceed.
Thank you. And Ms. Higgins, you go by DJ, is that correct?
Correct.
Okay. What's your relationship with Cullen? How long have you known him?
I'm a family friend of approximately 14 years.
Do you remember how you first met the family?
I worked with Cullen's mom.
Okay. Was that in the Department of Defense area?
Yes.
Are you still working there?
No, sir. I retired July 25th this year.
And in the course of working with his mother, did you get to know Cullen a little bit?
Yes. I would go to their house for holidays and dinners and cookouts and whatnot.
What did you observe about Cullen during your period of knowing him?
He's a good kid. He was raised well. I watched how him and his sister were raised. They were raised well. They did well.
Did you have occasion to see him with other young people?
I met one or two of his friends when we were all at the house. They're good kids.
Okay. And did you ever hear about anything that he might have done other than this incident that raised concerns with you?
No.
And you also work in pet safety or something?
Animal rescue.
Animal rescue.
Yes.
So you observed what happened today, and you
yes.
familiar with it.
Yes.
So you do not condone bad behavior?
Absolutely not.
Okay.
Right is right and wrong is wrong.
You're hardcore on that.
Very.
Okay. And you know that what Cullen did was wrong?
Yes.
In spite of that, do you think that he could succeed on community supervision if the judge would give him that?
With structure, accountability, and discipline, and having to stay focused on that thing, yes, I do. I think he would do very well with that.
And do you think that would be a better outcome than sending him to prison?
I do.
Why is that?
There's prison structure and there's, I don't know the right legal term, but probation structure.
Mm-hmm.
And I think him being employed, being forced to do the right thing every single day in a more open environment would be more beneficial to him to grow as a young man.
Any questions? All right, thank you.
Thank you.
Call your next witness.
Yes, I would call Melissa Daly.
All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
I'm Melissa Daly.
All right, just keep your voice up so the court reporter can hear. Defense, you may proceed.
Thank you, Your Honor. Ms. Daly, you're acquainted with Cullen O'Neill, correct?
Mm-hmm.
How did you know Cullen O'Neill?
I've known Colin since we met my son practically in kindergarten. And all the groups of boys always played in the neighborhood. So I watched basically Colin grow up since kindergarten.
Okay.
And he's always showed the utmost respect and yes, ma'am. And when I had groceries, he'd be the first to come help me take them out of the car. I had him spend the night several times. And I treated him like a son of mine. So this is totally out of character.
Mm-hmm.
But,
What is your son's name?
Daniel.
Daniel, and he is a friend and grew up with Cullen, correct?
Yes, sir.
Is Daniel here?
Yeah.
Daniel, okay. Now, would you, if you had had any issues with Cullen as far as his influence, would you have allowed Daniel to spend time with Cullen?
I hadn't had any issues with Cullen.
Right, but if you had.
Oh, of course I would. But I have not seen, Cullen has always presented great character and integrity. And I thought when he was raised with his father hunting and having all the things that every boy would dream to have with a dad do. Mm-hmm. And since his dad passed, it was very heartbreaking. But he had a group of friends that supported him. So he wasn't like a loner child. He had lots of friends. And that helped him get through that horrible situation during his prime time in childhood.
And do you think that that he would be a good candidate for probation, community supervision?
Yes, I do.
You think he could succeed on that?
I absolutely do think he succeeds. Has high integrity, and this is just outside his character in this incident.
Thanks. Absolutely.
Any questions?
No.
All right, thank you so much. Call your next witness.
I'm going to call Cullen, Your Honor. Cullen O'Neill.
Can you raise your right hand?
Sir.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Cullen O'Neill.
All right, defense, you may proceed.
Thank you. Cullen, you know why we're here?
Yes, I do. I made an egregious mistake one night. I had no sympathy for the situation I was in due to being under the influence of drugs and alcohol. And I made an honest young man mistake with my emotions and what I was trying to do. I made a horrible mistake. It's been haunting me. And I mean, I've had to deal with it for a year and a half that I've realized it and sat with it. And people have made fun of me. I've gone through it, but it's something that I know that it's not over because I made a mistake and I'm willing to take that on the chin. You know what I mean? You talk about football and LSU. I'm leaving it all on the field. You know what I mean? With what I'm trying to do to prove that I need a plea, but I made a mistake.
Okay. Now, at the evening this happened, you had been using drugs, correct?
Yes, sir.
And you'd been drinking.
Yes, sir.
So you have an issue with drinking and with drugs.
Yes.
And you're willing to deal with that.
100%.
Okay.
To get better.
To get better. Do you have an attraction to younger women?
No, ma'am. I mean, no, sir. I've never once ever in my life. I think it was just the influence I was in, the situation of not sleeping, being tired from work, and my emotions, my feelings as a young man just overcame me. And I know that's horrible and I made a mistake for that.
Okay. Now, you did complete your GED, correct?
Yes, sir, I did.
Okay. And do you have plans and things that you want to achieve in your life?
Yes. So I was a month away from finishing college when this all happened. And I had been held back for a year and a half to even finish college. But what I was doing in college was being a gunsmith. I get with my situation now, I might need to find a different line of work. And what I've been doing as an iron worker and doing stuff outside and building buildings like Chick-fil-A's, Walmart's, and Chase Banks and stuff around the community the best I can.
Now, you were employed with an iron, what kind of a company was it?
It was an iron company. It was Hill Country Steel. We do all the main steel around all of San Antonio, Austin, and Dallas. We do every Walmart, every Chick-fil-A, every Chase Bank,
Okay.
Every car wash, we provide the steel.
Well, did you start working with them when you were in high school?
Yes, right out of high school. One of the letters I gave was from the employer that I've known since right out of high school, and he helped me a lot. And he knew about my situation through house arrest and getting my job back.
Now, you're not currently working for him, right?
No, I stopped working for him because I wanted to deal with this and didn't want to interrupt their company for my mistakes.
And are you hoping to be able to get work again?
Yes, I actually have a job interview on Thursday for another steel company that was smaller that we used to provide steel with. So that's something I'm really looking forward to start doing and working.
Tell the judge why you think you could succeed on probation.
I did track, football, and baseball all throughout high school. And I work harder than most grown men that I know. And I know I messed up. And I don't want to do prison because that's just not something I know I will succeed in, unfortunately. But I know that doing the plea and being on a schedule, checking in and doing things like that will really help me a lot. Get my life back on track. I'm young. I made a horrible, horrible mistake for my age. And I know that I want to be able to recover from it and not be stuck.
Now, when this happened, understanding the situation, you do admit that you were told that the girl was 15.
Yes,
correct?
Yes,
and you also admit that when you were going to see her, it was because you were intending to have with her, right?
Yes, I admit to that. You know what I mean? I admit to the court to take my honesty because I made a mistake.
Yeah. But that's not something you have ever done.
Never thought about it, never once been around it. And I have a little sister. How could I do that to her?
Okay.
You know, like that's something that I really think about a lot and being a better image for her, especially with the situation I'm in. I want to get out of this and be better for her. And she was one of the main people that wrote a letter.
Okay. Pass the witness.
State.
Yes, ma'am.
You talked to probation prior to this hearing, correct? The pre-sentencing report?
Yes, ma'am.
And when they asked you about the offense, you minimized it, correct?
I was nervous to what I said. I was very nervous on what needed to be said. And I wasn't sure what to say. I've never been in a situation like this. And I've never had the thoughts that I had.
But when you spoke to probation, you did minimize what you did in this offense, correct?
I wouldn't say minimize. I told my side the best that I felt that I could. But I did make mistakes. I did say things I wasn't supposed to. And we're here in this situation because of my mistakes.
Right. And the officer didn't force you or coerce you into this situation.
I mean, it was a sting operation.
Correct. But you willingly agreed to meet this person. They didn't force you to meet them,
yes,
correct?
after like maybe 30, 45 minutes of time had passed since they had started talking to me, yes.
And you described in great detail and graphic language exactly what sex acts you wanted to perform on this 15-year-old. Is that correct?
Yes.
Pass the witness, Judge.
Any other questions?
No, Your Honor.
All right, any other witnesses?
No, Your Honor.
All right, court will hear brief argument. State.
Judge, I'll let defense go first.
Your Honor, Cullen O'Neill, in my opinion, is a perfect candidate for probation. He checks off the boxes, so to speak. He's 22 years old.
Okay, and not to interrupt your argument, counsel, but this.
Well,
no. This is what I wanted to address, but nobody addressed it. I don't know if anybody wants to address it. And it has to do with the thing that's mentioned in the PSI. And I don't know if you want to address part of that with your.
Yeah, I mean, I could ask him.
Okay.
If I could recall.
And I'm sorry about that. Yes, you could recall it.
Sure. You had cocaine that night, correct?
Yes, it was for myself, yes.
And you were using.
Yes, I was.
And you were, as you earlier testified, you were using alcohol too.
Yes.
And you had and did this problem develop like years before?
It mainly developed a year or so before, just working hard and just trying to stay up and just trying to deal with college and deal with a full-time job. I didn't know how to overcome myself or talk to, or And that's just what led me down the rabbit hole right there. And I just messed up.
And you understand that when you got to the point what happened that night, you were showing, you had an alcohol and drug problem. Right?
Yes, I definitely did.
And you have it now, correct?
I wouldn't say now. I have definitely resorted to staying off, being a lot better person just due to my probation with my ankle monitor. You know what I mean? Just in case, for whatever reason, they wanted to drug test me or whatever, God forbid, that they would do. I mean, and I have a little sister and my mom, and I don't want to keep that image. I really don't. You know, that's why I really would like, I don't mind doing drug tests, drug classes, or probation or whatever.
All right, and I just asked that because I forgot to bring it up so that could be cleared up because it was in the PSI. So sorry for the interruption.
Okay.
No, you're fine.
Are there any other questions?
No more questions.
All right, I'm sorry. You may proceed with your argument,
Okay,
counsel.
thank you. That charge was
Dismissed.
dismissed.
Yes.
Again, as I was saying, I think my main point is that Cullen is a very good candidate for probation. He has no criminal history. He is 22 years old. He has a very, very supportive family. He has friends that he's had since he was in kindergarten that are still his friends. I brought family members and I brought friends that have known him that are not related to him. All of them, including the letters that the court read from his employer and from other people that are friends that are not family. His sister did write a letter. All of them attesting to Cullen's character and their long history of knowing him. That isn't to say that what he did was not illegal and wrong. He should be punished for it. But he should, in my opinion, be punished in such a way that he is rehabilitated. This is a case where, to me, it cries out for rehabilitation, not for prison. Prison would be the opposite, in my opinion, of what should happen. Now, I know this is a crime that is extremely terrible, and there is a lot of outcry against this behavior. And I agree, it's fine. I'm not opposed to that. But in the appropriate circumstance, and I think this is one, a person that does this kind of crime can be rehabilitated and can go forward and contribute. And of all the people that I've represented for some time in the last couple of years, Cullen seems to me to be the best candidate for probation. And I'm hoping that the court will give him that opportunity. Whatever program, whatever monitoring the court feels appropriate, I'm asking the court to give him that chance.
All right, State.
Judge, I respectfully disagree with defense's view that this defendant is a great candidate for community supervision. This defendant has a pattern and throughout this case of hiding and minimizing his behavior. When he speaks with the undercover, instead of putting what he wants to do in a text message, he insists on talking. And he says those things over a voice message, so it's less traceable. He gets there, what happens, he gets arrested. He gets to this court, he pleads on this case to supposedly take responsibility. And when given that opportunity to take responsibility to the PSI officer, instead of just saying, I chose to go there that night, he says, well, she pushed me. The officer pushed me to do it. The undercover pushed me. He blames the undercover, doesn't take full accountability. And even today, he says, oh, well, the reason for that is I was scared. If his reaction to being scared, concerned, anxious, or nervous is to lie, to minimize, that is a terrible candidate for probation because he's going to keep doing it on probation. Judge, the descriptions in this report that the court has in the stipulations of what he specifically says, he's not just saying he wants to meet up and sex with a 15-year-old. He uses graphic sexual language, graphic violent language to talk about not only physically, but abusing a 15-year-old child. who he fully believes at that time is a 15-year-old child. I understand that this defendant is young. There may be some substance abuse issues. However, Judge, this is not the kind of person who I believe would be safe on our streets. I don't think he's a good candidate for probation, and I would worry about an actual child being harmed if he's let out. So I would respectfully ask the court to deny the applications for community supervision and sentence him under the plea agreement for 8 years.
All right. So, Mr. O'Neill, I want you to know that I heard everything from all of the witnesses. I reviewed the PSI. I internalized everything. I've read the chat messages that were sent to someone you thought was 15.
I messed up.
Yeah.
I messed up, Judge.
All right. Oh, it's okay if he says something.
No, I mean, I'm upset about this. You know what I mean? Like, it's just my life, you know? And I mean, I just want to fix it the best way I can.
All right. And I want you to know I'm taking in consideration your age. And I do understand that sometimes people will do things, they're intoxicated, be it through drugs or alcohol. However, in reading the stipulations and in reading the PSI reports, there were so many times that you could have just pulled back.
I did not understand. You know what I mean? I really did. If I had a better understanding, I would have been honest, like I have been today.
No. I'm not even. Here's the thing. This is what I understand. When probation officers are interviewing you for a PSI report, there are a lot of things going through your head, right? You don't want to say anything that could hurt you. Sometimes defense attorney, I was a defense attorney, and let me just tell you what I would tell my clients. I would tell them, for the love of all that's holy, just say, my attorney told me not to speak about it, right? And then sometimes I would have clients, I'm like, go ahead, tell them. So I will tell you what is in the PSI. I'm not holding that against you, because sometimes when people are faced with legal decisions, sometimes they get nervous. Sometimes you have a lot of voices in your head. What would my attorney say? I understand all of that. So I'm not holding that against you, that maybe you said something that could be considered you're not taking responsibility. So I want you to know that.
Yes, ma'am.
What I'm talking about is the offense. And it's like, there's so many points along the way that you could have stopped. Like, not drive over there.
Yes.
Not go to the hotel. Not go up to the hotel room.
I completely agree. And that's something that I've talked to myself and my mom and my family about, and my friends about, why I even did it. Because in no right state of mind ever have I ever thought that way or been in a situation like that. I crashed out. And I didn't know what sympathy was for the simple like the situation I was in. I really didn't. And I was young, I was sleep deprived, I was off drugs and alcohol, and I really did not mean to make that decision. And that's not who I am as a person. I've never lied to my mom or people about my situation. I've always been honest when they asked, especially how I got my job back. Mm-hmm. I had to sit there in front of a bunch of grown people and explain what happened. Mm-hmm. You know what I mean? And that's something I can't be unhonest about it, because look how it looks on a piece of paper. You know, no matter what I said, no matter what I did, it's what's shown. And I mean, that's what's here today in front of us. Like, and I made a mistake, but I don't believe that I deserve prison, because I want to be rehabilitated. I know I can work through what the police says. I know my punishment isn't over. It'll be at least 10 years that I'll have to deal with whatever the plea requires. And I know that.
All right. So this is what the court is going to do. The court is going to find you guilty. The court is going to order Chapter 62 compliance. There's a $3,000 fine, time and money to run concurrently. The court will sentence you to 3 years in the prison, give you credit for any time served. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, what that is, you'll need to speak to an attorney. Do you understand?
So 3 years?
Yes. But like,
Well, I have,
I'm sorry.
Okay.
You gonna talk to him? What?
Yes, here, but I have another thing I'd like to raise.
Yes.
This is not a 3G off.
No,
So I will.
I didn't.
Did the court retain jurisdiction?
I'll consider it. I tell you what, you can file whatever you want to file, and then the state, you can, make whatever arguments you want to make, counsel.
May I hug my mom?
No, you'll have to talk to the deputies. They're in charge of security.